The father's intent to disinherit one of two sons from $500,000 was never in doubt. In court, his estate planning paperwork was a different and costly question. Find out why $500,000 in life insurance proceeds went sideways in the Rinaldi case, plus 2 forms to check this week so your family can prevent this common money mistake. I'm Kelly Lise Murray, and this is Wealth Litigated, all the drama of true crime without the blood. In 15 minutes, we decode actually litigated money mistakes, legal consequences, and fixes for you so a court doesn't decide where your wealth ends up. Let's see how it litigated. In the Rinaldi case, what went sideways was how the life insurance was handled as part of the father's estate plan. And this is the mistake many make. After creating an irrevocable life insurance trust for an existing life insurance policy, 2 changes are needed with the life insurance company using the life insurance company's forms. Forms to change the owner were unsigned and rejected by the life insurance company. As a result, the ownership of the existing life insurance policy never changed. The father owned it personally. What's the consequence of that? The $1 million in life insurance proceeds would be included in his taxable estate, defeating the purpose of an irrevocable life insurance trust. That consequence is separate from the beneficiaries identified and confirmed with the life insurance company. In Rinaldi, the beneficiary forms were never sent. According to the life insurance company, that meant the beneficiaries remained Junior and the second son. The second son was not a beneficiary of the irrevocable life insurance trust, but he remained a beneficiary within the records of the life insurance company. To recap, the father signed the irrevocable life insurance trust in April of 2013. In January 2014, his trustee faxed the life insurer who rejected the change in ownership form. The insurer sent the 2 forms it needed to the father, not to the trustee, Junior, and not to the insurance broker of record. As a result, the 2 forms needed, the change of ownership, correctly completed and signed, the change of beneficiaries, correctly completed and signed, were never sent to the life insurance company. This is what the life insurance company wrote to the father in January of 2014. According to the federal district court, the insurer's letter to father warned no changes will be made until we receive the requested information and fully completed forms. Father took no action. His life insurance broker didn't receive this letter, took no action, and the trustee of the irrevocable life insurance trust, Junior, also took no action. The father passed away on January 24, 2015. 13 days later, the life insurance company sent a check to Junior for half of the policy, $500,000. What happened to the other half? It was frozen for 4 years during federal litigation in New Jersey because the life insurance company filed an interpleader asking a court to decide who was entitled to the other half of the $1 million life insurance policy proceeds. Between April 2015 and July of 2019, it took 4 years to figure out who gets the second half of the $1 million life insurance policy. Who gets the money is just as important as why that person gets the money. The federal trial court ruled that the irrevocable life insurance trust never owned the life insurance policy, that the beneficiary designations were never changed by the father who remained the owner of the life insurance policy, which means son 2, who was disinherited from the estate, nevertheless received the second half of the life insurance policy proceeds, $500,000. This is what you need to confirm this week. First, who owns your life insurance policy? Second, who gets the proceeds of your life insurance policy? If you purchased the policy and did not have an irrevocable life insurance trust at the time, you're the insured life, you're probably the owner, and then who separately did you designate as beneficiaries? If you make no changes with the life insurance company, that's how things stand. Once an irrevocable life insurance trust is created, 2 things need to be changed with the life insurance company using the life insurance company forms. Making sure those steps are completed and accepted by the life insurance company, will work in every state. If not, the litigation result depends on your state. That's the result in Rinaldi. Despite disinheriting the second son from the estate using all these other estate planning documents, the father and his elder law attorney failed to disinherit the second son from the life insurance policy beneficiary status. What they should have done, and what you need to confirm if you have an irrevocable life insurance trust created after you purchased the policy originally, who is the current owner from the perspective of the life insurance company? Who are the current beneficiaries from the perspective of the life insurance company? Does the current status on file with the life insurance company match your intent and what is written into your irrevocable life insurance trust? The answers to all of that was no for over a year with the Rinaldi irrevocable life insurance trust. They had a year to get this right and no one did anything. Those two forms seem really simple, but they are missed all the time. Nearly half of all irrevocable trusts are unfunded, just like the irrevocable life insurance trust in Rinaldi. Separately, keep this in mind. Changing policy ownership does not change policy beneficiaries. Merely changing who owns the life insurance policy does not change who gets paid by the life insurance company from its perspective. But this is where you and your team need to know how it litigates in your state. It is dangerous to never change anything or to change one but not the other. On Wealth Litigated, we've looked at this in episode 114, the Dudek case, episode 115, the legal deep dive on the Rinaldi case, and episode 110, that case concerned another separate danger, transferring the life insurance policy from personal ownership to ownership by the trustee of an irrevocable life insurance trust who's responsible for paying the premiums. In episode 110, the premiums were not paid and the life insurance lapsed. Have a look at that episode and make sure you have your systems in place to keep your life insurance policy premiums paid if you have successfully transferred ownership and beneficiary status to the trustee on behalf of the life insurance trust. Decoding the Rinaldi case so you and your family don't have to litigate this. Different states have different outcomes if all of the paperwork is not correctly changed with the life insurance company. The ownership forms with the life insurance company and the beneficiary forms with the life insurance company, that will be controlling. However, if you don't change ownership or you don't change beneficiaries after the creation of an irrevocable life insurance trust, when it's litigated, the result depends on which state you're litigating in and which state's law applies to your circumstance. Rinaldi follows what I refer to as the generic result. Have a look at episode 114 and the Dudek case. The generic result includes Georgia, North Carolina, and New Jersey, but put an asterisk because the Rinaldi case was resolved in federal court, which does not create binding state law precedent, even though that court interpreted New Jersey state precedent. Unlike those states, California, Kentucky, Nevada, and Ohio look to the trust itself to determine ownership of the policy and whether any beneficiary changes could have been made after the creation of the irrevocable life insurance trust. Recapping, the one method that works in every state is this. When you try to transfer an existing life insurance policy to a newly created irrevocable life insurance trust, you and your team complete, sign, submit, and get confirmation from the life insurance company that both ownership has been transferred to the trustee on behalf of the trust and the beneficiary has been transferred to the trustee on behalf of the trust. When you have confirmation of both of those, that will work in every state. Do none of that or only do part of that, you're litigating and your state's approach controls the outcome, not you and not the partial forms. Which brings us to 5 questions for you to ask this week to make sure that the proceeds of your life insurance will actually go where you want it to. Before contacting any of these 5, start with your own records. Do you have written confirmation about who owns your life insurance policy and who the beneficiaries are? Next, contact the life insurance company for the latest confirmation of ownership and beneficiaries. Get that in writing. If you have a life insurance broker of record, contact that office and ask them to get the current confirmation from your life insurance company. The trustee. Junior was the trustee of the Rinaldi Irrevocable Life Insurance Trust. It was his responsibility as trustee to confirm that the paperwork was completed correctly, submitted to the life insurance company, and confirmed by the life insurance company. If you are your trustee, that's you with that responsibility. But sometimes the trustee is a third party, and it is the responsibility of whoever is the trustee. Do you have an estate planner? Do you have an estate planning attorney? Or like Rinaldi, do you have an elder law attorney? Contact that office to confirm the current ownership and beneficiaries for your life insurance policy. Your wealth manager and financial advising team, what do they have in their records? They should have this written confirmation as well. Failed trust funding and unconfirmed paperwork is not wealth protection and may become wealth litigation. Thank you for joining us.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.